Good morning, John. Good morning, Sally. My name's Josh and I'll be your mediator today. So welcome to all parties, including your solicitors. So I'd like to talk to you just firstly about a few points. Firstly, my role as your mediator and that role of your solicitors. Secondly, the merits of settling today versus the demerits. Thirdly, the process and the structure I intend to follow for this mediation. And finally, some important rules. So my role today is to act as the mediator. I'm not a judge and I do not have the capacity to bind anyone to a decision. My job is to keep the negotiations going, to keep each of you working towards settling this dispute, so that each of you can get past this, all this trouble in your lives and get on with your lives. It is not my job to give you legal advice. That is what your lawyers are for, so make sure you make use of them. Your role is to make a genuine effort to settle this case. If either of you have come here today with the expectation that you have a starting point and you do not intend on moving from it, well, let me know now, because we may as well not even be here. Your lawyer's role really exists as an extension of your own. They are here to help you properly present your case and to provide you with legal advice. Okay, so today you each have a unique opportunity to take control of this dispute and to choose to accept a compromise. For that to happen, both of you will need to be able to do it. It is not for one person to do all the work and to give all the ground. If you can settle this case, then of course you will have sacrificed some money that you may have been able to claim if you had run the matter all the way to trial. But up to this point, I'm certain that each of you would have suffered massive discomfort and financial distress in finding the money to pay for your lawyers and the time and energy necessary to try and advance each of your respective cases. Okay, so how we propose to run the mediation today will be after this joint session, we'll break and each of you will go to your breakout rooms and I'll remain here in the common room. Because we'll be running this mediation as a shuttle format, you'll each be able to each have opportunities for timeouts and short breaks. So just let me know if you need some time. I also need to know if either of you are under any time pressures today to get this finished before a certain time.
No.
No? Okay, brilliant. I already understand John's case because he's given me a case outline position and that I've read. However, I do not know Sally's case. So for the purpose of the first while, we'll be spending that with Sally to understand her response to John's position. Once I understand both cases, at that stage, I'll be understanding each starting point as your best day in court. And then from there, we'll work backwards to what will be called best and final offer. Okay, so finally some important rules. Under the terms of the mediation agreement today that we've each signed, everything discussed between the parties and any offers of settlement which are made are all confidential. None of it can be used in subsequent proceedings in court. Secondly, there is an exception to Rule 1 if there is any disclosure made which indicates that one party is intending or has committed a crime or any form of child abuse. The confidentiality agreement no longer applies, and myself and each of the solicitors will be duty bound to alert the authorities. Okay, and number 3, because we're running the matter today as a shuttle conference, there will probably be no situation beyond this current meeting that each of you will be face to face. But in the event that does happen, and you're required to speak to each other, one party's quiet while the other one speaks, you're more than welcome to take notes, and then after that, you'll most certainly have your chance to speak. Okay, John, I'll get you to leave the room while I speak to Sally.
No problem.
Thank you. So I understand John's position statement, and I assume that you've done the same. In that document, he lists out all the assets and liabilities, which he says he says they are worth. He also lists the history of when the pair of you first started living together, a date of marriage, and a date of separation, in which case I can see it was a 9-year relationship, and he gives a summary of what is going on with your children. Jack and Mary, I believe their names are. He says that they're living 50% with him and 50% with you. Do you agree on all that information?
Yes.
Okay, thank you. So in regards to the percentage of the division, John says that before you and him even got together, he was gifted the farm, and that still represents about 70% of the total value of the assets. And I see that he argues that the first 70% should come off and be kept by him, which only leaves 30% available for division. And his argument is that that should go 50-50, leaving you with 15%. Now, can you provide me please with a response to that argument?
Yes, I agree on the straight math. The farm equity today represents 70% of the assets, which can be divided between us. And I agree that John also had the farm gifted to him before he and I got together. But when we first got together, he did not have that asset debt-free. It might have been worth, on paper, $3 million, but we had about $1 million in debt. And for the first 6 years of our relationship, things were really hard. We had 3 years of drought, and then straight after that we had 3 floods over the next 3 years. After operating costs, there was next to no money for any of us to live off. And plenty of times I was filling in doing farmhand work because we could not afford jackaroos, and all of that at the time when Jack and Mary were still barely out of nappies. I also had to go to work in town to supplement our earnings, and that was another 20 hours per week, which I was doing on top of taking on the main role for the care of the children. The mortgage repayments on that $1 million debt were huge, and if we did not do everything we did to raise enough money just to make the interest payments on that debt, the bank would have moved in and sold us up in that situation. I seriously doubt that we ever would have got $3 million for the property when we were trying to sell it in drought or flood conditions.
Okay, so you consider a settlement offer?
Yes, I think we should settle on a 50-50 basis.
Right. But am I correct in understanding that 50% would be your best day in court?
Yes.
Okay. But like I said in the joint session, we really need to be moving down from the best day in court. So I need you to make an offer in somewhere less than the 50% range.
Okay, I'll take 40.
Okay, thanks for that. But may I ask, based on the value and the makeup of the assets, 40% comes to about $2 million. Even if John handed over all the cash, all the cattle, and all of the farming equipment, that still only comes to $1.5 million. So where would he get the other $500,000 from to make up your $2 million offer? I mean, it seems that John is quite firm on the idea that he wants to keep the farm. And I can see from the history that you have each given me that there doesn't seem much chance that John would be able to borrow much more. Even if he handed over all of the cash, cattle, and the farm, and the farming equipment, he'd have nothing left to run the farm with. So, with that in mind, can you consider a better offer?
No, I want to stick with the offer of 40.
Okay. I'll take that to John and see what he says. Is there anything that we've spoken about here that is confidential to us?
No.
Okay, thank you. John, can I ask you to come back in, please? Okay, John. So, I've spent some time with Sally. I've really gone over the assets and spoken to her about her case. It seems to be that it can be broken down into 3 parts. Firstly, that the $1 million debt owed over the property, that's been there the whole relationship, and she seems to be quite stressed about the interest costs on that loan. Secondly, during the 6 years, previous 6 years, there's been 3 years of drought and 3 years of floods. And from what I'm understanding from both of you, that it was incredibly hard going. There's been no money to live off, and both of you have been doing it very tough. And finally, third point, Sally has had to take on extra work in town to take care of both the children and help out with the farm. Would you agree with all of that?
Yes, I would. It has been tough, but I've worked just as hard as Sally has.
Okay. Well, the offer that Sally's presented is 40%, which I can see works out to about $2 million.
That's ridiculous. There's no way she's worth that.
look, you may be right, you may be wrong, but there's one thing for sure, that is unless we can find some way to bridge the gap between the pair of you today, the next step is court. So I understand that you're not happy with that offer, but right now the power's with you. You've told me that your case is 70%, but that is your best day in court. So what offer are you prepared to make?
Does she realise I'd lose everything if I gave her the sort of money she's talking about?
Yes, she does appreciate that. I've had a very good talk to her about about all that, but even after that, she was still at 40%. That is just her opening offer though.
Okay.
What needs to happen now is you need to tell me what you can do to bridge the gap, because right now you guys are $1.25 million apart, and that's quite a lot of work to close that gap. So what are you willing to do?
Okay, look, I reckon she's pushing it at 15%, but I'll go up to 20%, so that's 1.25 million. And I'll make up all of the cash, half of the herb which I can sell down now, and there's also about $100,000 worth of farm equipment I can also sell off. So all of that would come to 850,000.
Okay. So how would you make up the balance of 400,000?
Sally will just have to take that in cattle sales over the next 5 years at $100,000 each year at the time we do our spring cattle sales.
Okay. Brilliant. So are you willing to secure that debt against that debt for Sally Adr?
Yeah, I can give her a second mortgage over the farm.
Okay. And I can take that offer to Sally?
Yes.
Okay, brilliant. So is there anything we've spoken about that's confidential to us?
No.
Okay, brilliant. I'll get Sally and I'll let her know.
Thank you.
Sally, can you please come back in? Thank you. So I've had a talk to John, and I told him his offer. I told him your offer, sorry. He wasn't prepared to accept it, and like I thought, the really big factor is that he wants to hold on to the farm. But he was prepared to make a counter offer.
Yes, so what is it?
Okay, so rather than talk about percentage, I think it's better right now if we talk about actual dollar values, because I think it makes it more real for everybody. So the cash amount of his offer is 1.25 million. It's made up from all the cash, $450,000 of cattle sales, and some of the farming equipment sales, with a balance of $400,000, and that will be made up from cattle sales over the next 5 years, round out to $100,000 each year when the spring cattle sales are finished.
Will John give me any security for this 400,000?
Yes, he was quite forthright about that actually. He's willing to give you a second mortgage over the farm property. The property's worth $4.5 million, and the current debt against it, as you know, is $1 million. So that still leaves $3.5 million in equity.
Okay, I don't like it, but I'll take it.
Okay, fantastic. So what we need to do now is have your lawyer and John's lawyer get together and draw up a heads of agreement. That document can be signed today, and then both your lawyers will do the work to get that converted into an order from the court. Thank you for your time, Sally. I'll just go and tell John. John, can you come back in, please? Okay, John, she's accepted your offer. Congratulations. So what happens now is that I need your lawyer and Sally's lawyer to get together to draw up a heads of agreement and turn that in, get that signed, and then we need to get that turned into a consent order from the court. And then it's binding on both of you. Thank you for your time, John.
Thank you very much, Josh.